Let me take this opportunity to say thank you for your service so far. Would you please stand, raise your right hands. Do you solemnly swear or affirm that you will well and truly try the issues joined between the Commonwealth and the defendant and render a true verdict according to the evidence? If so, please say I do. Is there anyone not so affirming? Now, I want to instruct you that I will be reading from written instructions in order to make sure that everything that I tell you is standard and uniform and in accordance with the laws of the Commonwealth. And I give you this as a warning, even though I will be reading to you, you must pay close attention to what I have to say. Members of the jury, you are about to perform one of the most serious duties of citizenship. You are going to decide whether a fellow person, the defendant, is guilty of a crime charged by the Commonwealth. The way you as jurors do your job is as important to the administration of justice as the way I do mine as a judge, the way the district attorney does his job as a district attorney, and the way the defense attorney does his job as a defense attorney. Pay close attention to everything that is said and done in this courtroom so that you can perform your duties well. The charges that are brought against the defendant are in a formal document called an information. The charge is an accusation, not proof that the defendant is guilty. A fundamental principle of our law is that you must presume the defendant innocent. This means that you are not to accept the mere fact that the defendant is charged with a crime means that he is guilty of it. He begins this case with a clean slate. He has no obligation to prove his innocence. It is the Commonwealth that bears the burden of convincing you that the defendant, who is presumed innocent as the trial begins and progresses, is guilty of the crimes charged. To succeed in its effort, the Commonwealth must convince you that, based upon a fair consideration of all the evidence that will be offered, each and every element of the offense charged has been proved beyond a reasonable doubt. To find the defendant guilty beyond a reasonable doubt, you must be convinced of his guilt to the same degree you would be convinced about a matter of importance in your own life in which you would act with confidence and without hesitation or doubt. I will describe in a general way what will take place. First, the district attorney will make an opening statement in which he outlines the Commonwealth's case against the defendant. The defendant's attorney will make a statement outlining the defense case, either immediately following the district attorney's opening or later in the trial. Second, the district attorney will present evidence. He may call witnesses to testify. He may offer exhibits such as documents or physical objects. The defense counsel has the right to cross-examine witnesses called by the district attorney in order to test the truthfulness and accuracy of their testimony. After the district attorney has presented the Commonwealth's case, the defense counsel may present evidence for the defendant. The defendant has no obligation to offer evidence or to testify himself. The district attorney may, of course, cross-examine any witness called by the defense. Third, after all the evidence has been presented, counsel for both sides will have an opportunity to make their closing arguments to you. I will then give you my final charge, which will include instructions on the rules of law that apply to the case and whatever additional guidance I think you need for your deliberations. You will then retire to the jury room to deliberate and to decide what your verdict will be. It is my responsibility to decide all questions of law. You must follow my rulings and instructions on matters of law, whether or not you agree with them. I am likely to give other instructions during the course of the trial in addition to these preliminary instructions and my final charge. You should consider all of my instructions as a connected series. Taken together, they constitute the law that you must follow. I am not, however, the judge of the facts. It is not for me to decide what are the true facts about the charge against the defendant. You, the jurors, are the sole judges of the facts. It will be your responsibility, and yours alone, at the end of the trial, when you deliberate, to evaluate the evidence and from the evidence find what the facts are. You will apply the rules of law that I give you to the facts as you find them to decide whether the defendant has been proven guilty beyond a reasonable doubt. Each one of us has biases about certain perceptions or stereotypes of other people. We may be aware of some of our own biases, though we may not share them with others. We may not be fully aware of some of our biases. Our biases often affect how we act, favorably or unfavorably towards someone. Bias can affect our thoughts, how we remember, what we see and hear, whom we believe or disbelieve, and how we make important decisions. As jurors, you are being asked to make very important decisions in this case. You must not let bias, prejudice, or public opinion influence your decision. You must not be biased in favor of or against any party or witnesses because of his or her disability, gender, race, religion, ethnicity, sexual orientation, age, national origin, or socio-economic status. Your verdict must be based solely on the evidence presented. You must carefully evaluate the evidence and resist any urge to reach a verdict that is influenced by bias for or against any party or any witness. While you are deciding the facts of this case, you will have to judge the credibility and weight of the testimony and other evidence. By credibility, I mean the truthfulness and accuracy of the evidence. When you judge the credibility and weight of a witness's testimony, you are deciding whether you believe all, part, or none of the witness's testimony and how important that testimony is. Use your understanding of human nature and your common sense. Observe each witness as he or she testifies. Be alert for anything in the witness's own testimony or behavior or for anything in other evidence that might help you judge the truthfulness, accuracy, and weight of his or her testimony. Under our law, you will not be given any written transcript of testimony to use during your deliberation. You must rely on your memories to recall the evidence and legal instructions. Therefore, listen carefully to everything that takes place. We have a court reporter who is taking a record of the proceedings. If you have trouble hearing questions or answers while a witness is testifying, raise your hand. If you missed anything significant, the recorder can read back whatever you missed. Although you will not be given a written transcript of the testimony to consult during your deliberations, if you ask, I will allow the reporter to read back particular testimony, but this can be difficult and time-consuming, especially if you ask for a lot of this help. Please pay close attention to the witnesses as they testify so that you will be able to remember the testimony during your deliberations. During the course of the trial, various exhibits may be introduced. Exhibits may consist of physical items, documents, and in some cases, transcripts of former testimony. Any exhibit that is admitted and that is referred to during the course of the trial may be considered by you. However, only certain exhibits are permitted to accompany you to the jury room during your deliberations. It will be for me to determine, as a matter of law, which exhibits may be sent with you at the time that you begin your deliberations in this case. Each of you must keep an open mind throughout the trial. In the oath you just took, you swore to do so. You should avoid forming opinions about the guilt or innocence of the defendant or about any other disputed question until the trial is ended and you begin your deliberations. Do not talk with each other about the evidence or any other matter relating to whether the defendant has been proven guilty until I send you to the jury room to deliberate upon your verdict. Only then will you know enough about the evidence and the law to discuss the case intelligently and fairly. In order to return a verdict, guilty or not guilty, that verdict must be unanimous. That means that all of you must agree. In the jury room, you will discuss the case among yourselves, but ultimately, each of you will have to make up your own mind. Therefore, each of you has a responsibility that you cannot avoid. You must do your best throughout the trial to fulfill this great responsibility. Do not concern yourself with what the punishment might be if you should find the defendant guilty. The questions of guilt and punishment are separate issues. If you do find the defendant guilty, it will become my responsibility as a judge to decide the punishment. In order for the jury system to work as intended, jurors must be absolutely impartial. One important way of making sure you are impartial is for you to only base your decision on information presented in the court. Therefore, our system of criminal law allows you to consider only the evidence, arguments, and legal instructions that are presented during the course of the trial. You must avoid anything that might result or appear to result in your being exposed to outside information or influence. Allowing outside information to affect your judgment is unfair and prejudicial to the parties and could lead to this case having to be retried. Therefore, you must not communicate with anyone else about the case or listen to others talk about the case until the trial is completely over and I discharge you. By communicate, I mean that I mean more than just not talking face-to-face with other people about the case. You are not to communicate with anyone about the case by cell phone, text message, email, or by posting information about the case or what you are doing as a juror on any website like Facebook, Twitter, Google, or any other similar website. You cannot even discuss the case with members of your family, close friends, or court personnel until after your verdict is completed and I discharge you. You must not have any conversations, even casual conversations, with the defendant, counsel for either side, or any witness. And you are not permitted to discuss the case with other members of the jury until after I give you my final instructions and I send you back to begin your deliberations. Do not read, listen to, watch anything about the case in newspapers, magazines, or on radio or television or the internet. Do not try to get information relevant to the case on your own. Do not make any investigation, do any research, visit the scene, or conduct any experiment. Do not conduct any internet search about the facts of the case, the participants, or the law regarding these matters. You are specifically prohibited from using a computer, cell phone, or other electronic device with communication capabilities at any time during your attendance at trial or during deliberations. These devices can be used during a break or recess in a proceeding, but may never be used to obtain any of the following types of information. Information about a party, witness, attorney, judge, or court official. Newspaper reports about the case. Information connected through juror research about the case. Information connected through juror research about any topic raised or in any testimony offered by a witness. Information collected through juror research or on any topic that you or another juror might think would be helpful in deciding your case. You must understand that any prospective or selected juror who uses an electronic device for one of these reasons, as I have indicated, or who records or broadcasts any of the events occurring during this judicial proceeding, or who otherwise violates any specific instructions I have given you regarding the prohibited use of electronic devices during these court proceedings, may be found in contempt of court and may be subject to fine, imprisonment, or both. That juror may also be subject to whatever sanctions I deem appropriate, including the confiscation of the electronic device improperly used in violation of these rules. You should also report to me immediately any violation of these rules by anyone who is either a prospective or a selective juror of this matter. As I told you earlier, you are the sole judge of the facts and of the credibility and of the weight of the evidence. You must rely on your own recollection and evaluation of the evidence during your deliberations and not on mine or counsel's. You are not bound by any opinion that you consider or I might express about guilt or innocence, credibility or weight of the evidence, facts proven by the evidence, or inferences to be drawn from the facts. Any inference is a deduction. For example, if everything is wet outdoors, you might infer that it had been raining. You should consider the statements and arguments of counsel carefully, even though they are not binding on you and are not evidence. You may be guided by them if the statements and arguments are supported by the evidence and appeal to your reason and judgment. The questions of counsel put to the witnesses are not evidence. The same is true of any questions that I might ask. You should not guess that a fact is true just because one of the attorneys or I asked a question about it, if it is the witness's answer that provides the evidence. Of course, you may have to consider the question to know what a witness means by his or her answer. For instance, if a witness responds yes to a question, you have to know the question to understand what the witness is really saying. Part of my job is to rule on any objections to evidence made by counsel. If I decide that evidence is admissible, I will overrule the objection. This simply means that you are entitled to hear and consider the evidence. On the other hand, if I decide evidence is inadmissible, I will sustain the objection. This means that you are not entitled to hear the evidence. Sometimes I may offer evidence stricken from the record after you hear it. Whenever I sustain an objection and order the evidence stricken from the record, you must completely disregard that evidence when deciding the case. Counsel and I have to deal with matters that you are not supposed to know about. When one of these matters comes up, counsel and I may discuss it at the bench, in my chambers, or in the courtroom, and I may ask you to leave. Please do not try to guess what we are talking about. I have now completed my preliminary instructions to you. We will take a brief recess and we will begin with the district attorney presenting his case. Members of the jury, now that all the evidence has been presented and the attorneys have made their closing arguments, it is my duty to instruct you in the law which you will apply in reaching your decision in this case. You will only apply the law in which I instruct you. You will not apply any other law that you know or think you know. In doing so, I am going to be reading from written material in order to ensure that it is in accordance with the laws of the Commonwealth of Pennsylvania. I tell you this as a warning. Even though I will be reading, you must pay close attention because these instructions will provide you with the tools you will need to reach your decision in this case. A fundamental principle of our system of criminal law is that the defendant is presumed to be innocent. The mere fact that he was arrested and is accused of a crime is not any evidence against him. Furthermore, the defendant is presumed innocent throughout the trial, and unless and until you conclude, based upon careful and impartial consideration of the evidence, that the Commonwealth has proven him guilty beyond a reasonable doubt. It is not the defendant's burden to prove that he is not guilty. Instead, it is the Commonwealth that always has the burden of proving each and every element of the crime charged and that the defendant is guilty of that crime beyond a reasonable doubt. The person accused of a crime is not required to present evidence or prove anything in his own defense. If the Commonwealth's evidence fails to meet the burden, then your verdict must be not guilty. On the other hand, if the Commonwealth's evidence does prove beyond a reasonable doubt the defendant is guilty, then your verdict should be guilty. Although the Commonwealth has the burden of proving that the defendant is guilty, this does not mean that the Commonwealth must prove its case beyond all doubt or to a mathematical certainty, nor must it demonstrate the complete impossibility of innocence. A reasonable doubt is a doubt that would cause a reasonably careful and sensible person to hesitate before acting upon a matter of importance in his or her own affairs. A reasonable doubt must fairly arise out of the evidence that was presented or out of the lack of evidence presented with respect to an element of the crime. A reasonable doubt must be a real doubt. It may not be an imagined one, nor may it be a doubt manufactured to avoid carrying out an unpleasant duty. So to summarize, you may not find the defendant guilty based upon a mere suspicion of guilt. The Commonwealth has the burden of proving the defendant guilty beyond a reasonable doubt. If it meets that burden, then the defendant is no longer presumed to be innocent and you should find him guilty. On the other hand, if the Commonwealth does not meet its burden, then you must find the defendant not guilty. The evidence in this case is of two different types. On one hand, there is direct evidence, which is testimony by a witness from his or her own personal knowledge, such as something that he or she saw or heard himself or herself. The other type is circumstantial evidence, which is testimony about the facts that point to the existence of other facts that are in question. An example of this is the following. Suppose you retire on a winter night. When you awake, you discover that snow has fallen and that there are footprints in the snow. You would properly conclude that snow had fallen during the night and that someone had walked through the snow. This is an example of circumstantial evidence. Whether or not circumstantial evidence is proof of other facts in question depends in part upon the application of common sense and human experience. You should recognize that it is sometimes necessary to rely upon circumstantial evidence in criminal cases, particularly where the crime was committed in secret. In deciding whether or not to accept circumstantial evidence as proof of the facts in question, you must be satisfied, first, that the testimony of the witness is truthful and accurate, and second, that the existence of the facts the witness testifies to leads to the conclusion that the facts in question also happened. Circumstantial evidence alone may be sufficient to prove the defendant's guilt. If there are several separate pieces of circumstantial evidence, it is not necessary that each piece standing separately convince you of the defendant's guilt beyond reasonable doubt. Instead, you may find the defendant guilty of all the pieces of circumstantial evidence when considered together must reasonably and accurately lead to the conclusion that the defendant is guilty and must convince you of the defendant's guilt beyond a reasonable doubt. In other words, you may find the defendant guilty based on circumstantial evidence alone, but only if the total amount of quality of that evidence convinces you that the defendant is guilty beyond a reasonable doubt. The Commonwealth has introduced evidence of a statement that it claims was made by the defendant. Before you may consider the statement as evidence against the defendant, you must find that a crime was in fact committed. Otherwise, you must disregard the statement. Each juror should ultimately decide these questions for himself or herself and therefore individually accept or reject the defendant's statement as evidence. You must not allow the fact that I admitted the statement into evidence influence you in any way during your deliberations. The defendant did not take the stand in this case. As I previously instructed you, the defendant has no obligation to offer testimony in his defense. Giving you these instructions for educational purposes, during the course of a trial, a judge has to decide what instructions to give to the jury at the conclusion. During the course of a trial, the defense counsel may decide to let his defendant take the stand or not take the stand. Often, if the defendant does not take the stand, the defense attorney will not want any instruction concerning whether he had taken the stand, and to do so over objections could potentially be reversible error. On the other hand, counsel sometimes want an instruction that the defendant is presumed innocent, he has no obligation to take the stand, or to present any evidence in his defense. However, if the defendant decides to take the stand, the following instruction will be given. The defendant took the stand as a witness. In considering the defendant's testimony, you are to follow the general instructions I gave you for judging the credibility of a witness. You should not disbelieve the defendant's testimony merely because he is the defendant. In weighing his testimony, however, you may consider the fact that he has a vital interest in the outcome of the trial. You may take the defendant's interest into account, just as you would the interest of any other witness, along with all other facts and circumstances bearing on credibility, and making up your minds what weight his testimony deserves. When there is a conflict in the testimony, the jury has the duty of deciding which testimony to believe, but you should try first to reconcile, that is, fit together any conflicts in the testimony if you can do so fairly. Discrepancies in and conflicts between the testimony of different witnesses may not be cause for you to disbelieve some or all of the testimony. Remember that two or more persons witnessing an incident may see or hear it happen differently. Also, it is not uncommon for a witness to be innocently mistaken in his or her own recollection of how something happened. If you cannot reconcile a conflict in the testimony, it is up to you to decide which testimony, if any, to believe and which to reject as untrue or inaccurate. In making this decision, consider whether the conflict involves a matter of importance or merely some detail, and whether the conflict is brought about by an innocent mistake or by an intentional falsehood. You should also keep in mind the other factors already discussed, which go into deciding whether or not to believe a witness. In deciding which of conflicting testimony to believe, you should not necessarily be swayed by the number of witnesses on either side. You may find that the testimony of a few witnesses, even of just one witness, is more believable than the opposing testimony of a greater number of witnesses. On the other hand, you should also consider the extent to which conflicting testimony is supported by other evidence. In this case, I permitted an expert to testify. An expert witness is a person who has special knowledge or skill in some science, art, profession, occupation, or subject that the witness acquired by training, education, or experience. Because an expert has special training, knowledge, or skill, he or she may be able to supply jurors with specialized information, explanations, and opinions that may help in deciding a case. Regular witnesses are bound by two limitations that do not apply to an expert. First, regular witnesses generally can testify only about things that they personally perceived, things that they saw and heard themselves. And second, regular witnesses are not allowed to express opinions about matters that require special knowledge or skill. By contrast, an expert is allowed to express an opinion about a matter that is within the area of his or her expertise. Furthermore, while an expert may base an opinion on things personally perceived, he may also base his opinion on factual information that he has learned from other sources. If an expert witness bases an opinion on things not personally perceived, he or she can describe the information on which he or she relies and identify its source while explaining the opinion. Remember, you as jurors are the sole judges of the credibility and weight of all testimony. The fact that the lawyers and the defendant may have referred to certain witnesses as expert and that the witnesses may have special knowledge or skill, this does not mean that their testimony or opinion are right. When you are determining the credibility and weight of an expert's testimony or opinions, consider all the factors that I described earlier that are relevant when evaluating the testimony of any witness. You should also consider all other things bearing on the credibility and weight, including the training, education, experience, and ability of each expert, the factual information on which he or she based an opinion, the source and reliability of that information, and the reasonableness of any explanation he or she gave to support the opinion. The speeches by the lawyers are not part of the evidence. That would be their closing statements and opening statements, and you should not consider them as such. However, in deciding a case, you should carefully consider the evidence in light of the various reasons and arguments each side presented. It is the right and duty of each lawyer to discuss the evidence in a manner that is most favorable to the side that he or she represents. You should be guided by each side's arguments to the extent that they are supported by evidence and insofar as they aid you in applying your own reason and common sense. However, you are not required to accept the arguments of either side. It is for you and you alone to decide the case based upon the evidence as it was presented from the witness stand and in accordance with the instructions that I am now giving you. You should not decide this case on the basis of which side presented the greater number of witnesses or the greater amount of evidence. Instead, you should decide the case on which witnesses to believe and which evidence to accept on the basis of whether or not the testimony or evidence is believable. In deciding which of several witnesses to believe, it is proper for you to consider whether or not the testimony of each witness is supported by other evidence in the case. However, you should recognize that it is entirely possible for a single witness to give truthful and accurate testimony, and that his or her testimony may be believed even though the greater number of witnesses of apparently equal reliability contradicted him or her. The question is for you to decide based upon the considerations that I am discussing with you. It is not which side produced the most evidence, but instead which evidence you believe. I will now give you instructions on the specific charges against the defendant. The defendant has been charged with driving under the influence of alcohol or a controlled substance. The defendant has been charged with violating the blood alcohol prohibitions of Section 3802 of the Pennsylvania Motor Vehicle Code, which makes it a crime to drive a vehicle after imbibing a sufficient amount of alcohol such that the alcohol concentration in the individual's blood or breath is at least 0.08% within 2 hours after the individual has driven the vehicle. Let me take a moment to explain the findings of fact that you will be required to make with respect to the defendant's blood alcohol level. The levels are determined according to the concentration of alcohol in the defendant's blood or breath. The threshold of guilt under this section of the law is 0.08%. Because the defendant's blood alcohol concentration is a fact that the Commonwealth must prove beyond a reasonable doubt, you must decide what the defendant's blood alcohol concentration was within 2 hours of driving, operating, or being in actual control of the vehicle. I will now instruct you on the elements of the offense. To find the defendant guilty of this offense, you must be satisfied of the following 3 elements and that they have been proven beyond a reasonable doubt. First, that the defendant imbibed alcohol. Second, that the defendant then drove, operated, or was in actual physical control of the movement of a vehicle upon a highway or traffic way. Third, that within 2 hours after driving, operating, or being in actual physical control of the vehicle, the alcohol concentration in the defendant's blood was 0.08% or greater. Specifically, you must decide on the verdict slip the defendant's blood alcohol reading. The specific amount that you must determine would be from 0.08% to 0.09%, or 0.1% to 0.159%, or 0.16% or greater. On the verdict slip, you should select the highest range of alcohol concentration that has been proven beyond a reasonable doubt and place a check mark on the blank line next to that range. All other lines should remain empty. The defendant has also been charged with homicide by vehicle while driving under the influence. To find the defendant guilty of this offense, you must find beyond a reasonable doubt the defendant violated one of the provisions of Section 3802 of the Vehicle Code, which defines the crime of driving under the influence, as I have previously instructed you. If you find the defendant is guilty of driving under the influence, in order to convict the defendant of homicide by vehicle while driving under the influence, you must then find that the Commonwealth has proven each of the following additional elements beyond a reasonable doubt. First, that the victim is dead. Second, that the defendant negligently caused the death of the victim. A person acts negligently when he or she should have known of a substantial and unjustifiable risk that his or her conduct will cause serious bodily injury. The risk must be of such a nature and a degree that the defendant's failure to perceive it, considering the nature and intent of his conduct and the circumstances known to him, involves a gross deviation from the standard of care that a reasonable person would observe in the defendant's situation. And third, that the defendant caused the death of the victim as a result of his driving under the influence. In order to be a direct cause of death, the person's conduct must be a direct and substantial factor in bringing it about. There can be more than one direct cause of death. A defendant who is a direct cause of it may be criminally liable even though there are other direct causes. A defendant is not a direct cause of death if the actions of the victim or the actions of a third party plays such an independent, important, and overriding role in bringing it about, compared with the role of the defendant, that the defendant's conduct does not amount to a direct and substantial factor in bringing about the death. A defendant's conduct may be a direct cause of death even though his or her conduct was not the last or immediate cause of it. Thus, the defendant's conduct may be a direct cause of the death if it initiates an unbroken chain of events leading to the death of the victim. A defendant whose conduct is a direct cause of the death cannot avoid liability on the grounds that the victim's pre-existing physical infirmities contributed to his or her death. If you find these elements proven beyond reasonable doubt, you may find the defendant guilty of homicide by vehicle while driving under the influence. Otherwise, you must find the defendant not guilty of the offense. Aggravated assault by vehicle while driving under the influence. The defendant is charged with aggravated assault while driving under the influence. To be guilty of this offense, you must find beyond a reasonable doubt that the defendant violated the provisions of Section 3802 of the Vehicle Code, which defines the crime of driving under the influence, as I have previously instructed you. If you find that the defendant is guilty of driving under the influence, in order to convict the defendant of aggravated assault while driving under the influence, you must find that the defendant has proven each of the following additional elements beyond a reasonable doubt. First, that the defendant negligently caused serious bodily injury to the victim. A person acts negligently when he or she should know of a substantial and unjustified risk that his or her conduct will cause serious bodily injury. The risk must be of such a nature and degree that the defendant's failure to perceive it, considering the nature and intent of his or her conduct and the circumstances known to him or her, involves a gross deviation from the standard of care that a reasonable person would observe in the defendant's situation. Serious bodily injury means any bodily injury that creates a substantial risk of death or that causes serious, permanent disfigurement or protracted loss or impairment of the function of any bodily member or organ. Second, that the defendant caused the serious bodily injury to the victim as a result of his driving under the influence. In order to be a direct cause of serious bodily injury, a person's conduct must be a direct and substantial factor in bringing it about. There can be more than one direct cause of a serious bodily injury. A defendant who is direct cause of it may be criminally liable even though there are other direct causes. A defendant is not a direct cause of serious bodily injury if the actions of the victim or of a third party play such an independent, important, and overriding role in bringing it about compared with the role of the defendant, that the defendant's conduct does not amount to a direct and substantial factor in bringing about the serious bodily injury. A defendant's conduct may be a direct cause of serious bodily injury even though his or her conduct was not the last or immediate cause of it. Thus, a defendant's conduct may be a direct cause of the serious bodily injury if it initiates an unbroken chain of events leading to the injury of the victim. If you find these elements proven beyond a reasonable doubt, you may find the defendant guilty of aggravated assault by vehicle while driving under the influence. Otherwise, you must find the defendant not guilty of this offense.
Anytime.
Concerning the charge of involuntary manslaughter, a defendant commits involuntary manslaughter when he or she directly causes the death of another person by reckless or grossly negligent conduct. The defendant has been charged with involuntary manslaughter. To find the defendant guilty of this offense, you must find the following elements have been proven beyond a reasonable doubt. First, that the victim is dead. Second, that the defendant's conduct was direct cause of his death. And third, that the defendant's conduct was reckless or grossly negligent. The term reckless or grossly negligent means the same thing. A defendant's conduct, including any failure to perform a legal duty, is reckless or grossly negligent when he or she is aware of and consciously disregards a substantial and unjustifiable risk that death will result from his or her conduct, the nature and degree of the risk being such that it is grossly unreasonable for him or her to disregard it. In deciding whether the defendant's conduct was reckless or grossly negligent, you should consider all relevant facts and circumstances, including the nature and intent of the defendant's conduct and the circumstances known to him at the time. I have now given you the specific charges which you will decide in your deliberations in this case. There are other charges which the defendant is accused, which are underage purchase, consumption, possession, or transportation of alcoholic beverages, reckless driving, maximum speed, and failure to obey traffic signals. It is a responsibility of the court to make the determination on those charges. You must make your determination on the other charges as I have specifically instructed you. Before you retire to decide the case, I would like to provide you with some final guidelines for the way in which you conduct your deliberations and how you may properly arrive at a verdict. It is my responsibility to decide all questions of law. Therefore, you must accept and follow my rulings and instructions on matters of law. I am not, however, the judge of the facts. It is not for me to decide what are the true facts concerning the charges against the defendant. You, the jurors, are the sole judges of the facts. It is your responsibility to consider the evidence, to find the facts, and applying the law to the facts as you find them to decide whether the defendant has been proven guilty beyond a reasonable doubt. Your decision in this case, as in every case you hear, is a matter of considerable importance. Remember that it is your responsibility as jurors to perform your duties and reach a verdict based on the evidence as it was presented during the trial. However, in deciding the facts, you may properly apply common sense and draw upon your own everyday practical knowledge of life as each of you has experienced it. You should keep your deliberations free of any bias or prejudice. Both the Commonwealth and the defendant have a right to expect you to consider the evidence conscientiously and to apply the law as I have outlined it to you. In arriving at the verdict, you should not concern yourselves with any possible future consequences of your verdict, including what the penalty might be if you should find the defendant guilty. The question of guilt and the question of penalty are decided separately. Upon retiring to deliberate, you should select one of you to serve as a foreman. He or she is the one who will announce the verdict in this courtroom after you have finished your deliberations.
And
your verdict must be unanimous. This means that in order to return a verdict, each of you must agree to it. You have a duty to consult with each other and to deliberate with a view towards reaching an agreement, if it can be done without doing any violence to your individual judgment. Each of you must decide the case for yourself, but only after there has been impartial consideration with your fellow jurors. In the course of your deliberations, each of you as jurors should not hesitate to re-examine your own views and change your opinion if convinced it is erroneous. However, no jurors should surrender an honest conviction as to the weight or effect of the evidence solely because of the opinion of your fellow jurors or for the mere purpose of returning a verdict. In closing, I would also like to suggest that you will be able to deliberate more easily and in a way that will be better for all concerned if each of you treats your fellow jurors and their views with the same courtesy and respect as you would other persons in your everyday life. Bailiff, please assist the jury in retiring to the deliberation room and provide the verdict slip to them.